Joining us now to discuss the copyright licensing of public performances is Dr. John Asein. He's the Director General, Nigeria Copyright Commission. Thank you so much for being here.
Good to be here again. Thank you.
You know, like Keke said, Ogungbe said, I mean, you're eating fresh fish, you're drinking, now you have to pay. It's not free. But Nigerians will be wondering, if music is meant to be shared, why do I have to pay for it? Explain why this is important. And for those businesses, like Tunji Olanipeko said, is this not extra burden for businesses that are already struggling?
Well, thanks for having me, and I must thank you for the perspective you're bringing to this. In the first place, it's not about being charged because you're eating fish.
That's why you're eating fish and listening to music.
To make that clear. In a lounge or in a facility, hotel or wherever, I guess the person setting it up would have looked at all the components. You pay for security, you pay for the everything you use, the food, the drinks. You pay for the services being rendered, your staff, even the ones you outsource. You pay for every other thing. And when it comes to paying for the component, the creative component, then there's this question of why should you pay for music? Why should you pay for the audiovisual works that are being shown? And what the law says, what the practice has always been, is that you should compensate those whose works you are using to run your business. I guess the music is as much part of the business as the electricity you are using or the security man that is helping you to keep the place safe. So everyone in the value chain, everyone in producing or providing some service to you deserves to be compensated. And I think that's what the right owners are asking for.
Well, I mean, fair enough, but, you know, one wonders if this is not just another revenue drive. But then again, how easily will it be to enforce this? Does the NCC have the capacity?
Okay. Well, first, thank you so much. I do agree with you that this should call for more enforcement, more vigilance. But it's not anything new. It's always been there. I mean, for instance, the music CMO in Nigeria was established in 1984. The AVRS was established 2013.
What are those, just for clarity?
Well, the music CMO, or Collective Management Organization, is the Musical Copyright Society of Nigeria, MCSN. And then AVRS is Audiovisual Rights Society of Nigeria. And they have their counterparts in every other country. Every country that you can think of will have a CMO. They will have the framework for licensing of works for use in commercial areas. Now, they've been paying. I mean, it's nothing new. Some have always been paying. In fact, in today's program that we had the speaker, the lead speaker, coming to say that they've always been paying. Their facility has always been paying, both for music and for the audiovisual works they use. So for any business that knows how it should be run and is running based on global best practice and the law, they know they have to pay. Now, what has happened is, and this is not new in the law, it's always been in the law. Interestingly, we have two cases that came up very recently. One was delivered on the 24th, incidentally, of July. It was a hotel that went to court and said, look, these people should not collect money from me. They don't even have a right. And the judge said, no. So long as these rights have been given to these people to manage, they have a basis for making the claim. Secondly, you are not supposed to have a public performance of their work without a license. So the one that went to court lost out. There was another one in August concerning music. The first one was for audiovisual works. In the case of the music, the court threw out the case because they found that there was no basis. Way back from the 80s, we've had judges, courts saying that whenever there's a public performance of a work, when you use work for commercial purposes, it's a secondary use of that work, and you are supposed to pay.
Okay.
So how do you enforce?
Well, there are two levels of enforcement. One is the civil, which means the CMO can go to court, and CMOs have been going to court, and they have a long list of cases where the courts have upheld that. The second is the criminal, where the NCC comes in. And in escalating, we've come to say that, look, before we escalate to the criminal level, we want you to know that this is how you should do your business. And that's why we are going with the enlightenment, education, reaching out, after which we will be forced to escalate. Because you can't just have the right owners, the creatives, suffering while someone is smiling to the bank using their works.
Well, that brings me to my question, because when you talk about enlightenment, I want to talk about the artists themselves. Are they enlightened enough to know that, they do own rights to get these taxes? And I ask you that because the industry is saturated. There's so many people singing. There's so many people who want to be heard. And I've worked in radio stations before. We all know what the practice are around the country. They beg you, they bring the music to you, the property to you to help them use, and frantically sometimes they just want to be heard.
In fact, they're ready to pay you
yes,
to play
to help them
instances.
play this. So when the artists go to these places we're talking about and beg for their, their works to be used, who then do you blame? I mean, in trying to check this, are you sure you're not going to be creating a situation where you discourage people? I mean, even the big stars we have today, some of them will tell you their stories of how they had to beg a DJ to play their music to be heard somewhere, and that's how, it picks up. So there's that on that hand. And then on the other hand of enlightenment, when is that going to commence, and what's the scale of it beyond this forum you had today?
Well, we're already doing the enlightenment, but we're going to scale up on that, and we'll do everything to reach out to the associations, because it's easier to go through the associations of hotel owners, for instance, and through them you can reach their members. We speak to them when they have their meetings, and we tell them what the law says. We'll do everything to saturate and get them informed. But I must say that the major players are well informed. I mean, the major hotel chains know that they pay. There's no hotel chain that is at that level that operates outside the country that doesn't know that they pay outside. So it's nothing new. Now, the argument about an artist going to a radio station and asking a
bars,
DJ to
lounges.
play, well, that happens everywhere. But the courts have, in the UK, for instance, that argument was brought up, we're promoting them. And the court said, no. There's a line you must draw where you stop promoting, you are now using and exploiting the work. And most of the works we are talking about here are not people who are begging to be played. Right. These are people that you need to use and draw your customers. So when, for instance, a hotel wants to entertain people in a lounge, or they want to play something good in their lobby, they're not going to look for a struggling artist. They're going to play music that people can relate with.
But isn't that segregation? I mean, a struggling artist want to be heard.
What I'm saying that for the artist that is upcoming, you could go to a radio station and say, okay, play me. That itself is a license. Okay? So that would not excuse the radio station now using other works without proper licensing. For instance, those in broadcasting know that there used to be a time that you have your log, you do your logging.
Yeah.
So it's always been the practice.
Okay.
And what we're doing now, or what we're calling for now, is not a new model.
Okay.
It's just for people to treat the artist right and know that it's not just a moral obligation. It's not just a business, that makes sense. It's also a legal imperative.
Right.
Otherwise, you'll be in infringement.
Very quickly, the point was made that there's a need to clearly state the terms of licensing and the extent of it. Then again, there's a concern of, for want of a better expression, maybe double jeopardy. Cable TV, for example, you pay for your cable TV. Are you saying that, again, within the content of an artist performing, you still pay as a consumer of the artist's work? Okay. Is it not double charges, double payments, double
For the
taxation?
Nigerian Copyright Commission, we want to, be fair to everyone.
Right.
So we're not coming to back up the CMOs. We're asking everyone to ensure that they play by the rules or do things by the rules. So for the cable stations, we're saying that you don't just say you've given licenses. The terms of those licenses must be very clear to us. And if we find that you are in breach or you're not giving them value for their money, then we'll call you to order. If we need to talk to the NBC and ensure that things are done properly, we'll do that. So no one should shortchange the consumers. Now, when it comes to using the cable license, for example, what you get as a domestic, viewer is different from what they should give to a hotel. And when they give to a hotel, the terms of the license will spell out where they can show those movies or the music. So once they go beyond that and begin to show or play them outside of what is allowed, then that will be another level of use. And in many cases, what we found is that these hotels go beyond what they're allowed to do under the subscription that they have with the cable stations.
All right. Someone said, I mean, the major hotels. How about the numerous ones you don't know? But we have to say thank you so much, Dr. John Asein, Director General, Nigeria Copyright Commission, for being here.
Thank you.
We do appreciate your time.
Thank you so much.